we will go ahead and call this meeting to order. Welcome to the Senate Committee on Growth and Infrastructure. I trust at this point folks are fairly familiar with the rules of the committee and the procedures and the ways to participate for those who are listening. If you need some assistance participating in today's meeting, you can find the committee email address on the agenda, and someone will get right back to you on the best way to participate. But we're going to go ahead and get started. If the secretary would please call the roll.
Senator Brooks. Here. Senator Hammond. Senator Pickard. Senator Spearman. Chair Harris.
Here we have 2 members present. We do not currently have quorum, and so we will be starting off in a subcommittee. With that, we will open up the hearing on AB 32, which revises provisions relating to the towing or immobilization of a motor vehicle. And I believe we have some folks from the Nevada Supreme Court here to testify. Judge Saragosa, how are you today? You can go ahead and begin when you're ready.
Chair Harris, thank you very much. I am with the Las Vegas Justice Court. I'm the Chief Judge of Las Vegas Justice Court, and it is my court that proposed this bill to the Supreme Court today. The bill is designed to provide some procedural clarity in handling unlawful tow cases. For your reference, these cases come before the justice courts in an expedited fashion when a person believes that their vehicle was either unlawfully towed or immobilized through a boot mechanism. And then the court determines whether the vehicle was lawfully or unlawfully towed or immobilized. The expedited nature is for the court to ensure that we can make a quick decision on how that vehicle was towed and whether it was appropriate or not, so that in those circumstances where it was unlawfully towed, the vehicle owner can get that vehicle back as quickly as possible, so as not to have a complete disruption of their lives and ability to drive to work and school and other places they need to go. A second consideration that comes up at the hearing is the determination of the amount of money that is due for any storage of that vehicle, and which party, and sometimes not even a party, is liable for the storage costs. So in looking at the bill, Section 1 of the bill provides clarity that the remedy for the court to decide whether the storage company has to return the vehicle to the vehicle owner or not is an expedited remedy over possession of that vehicle only. It is not intended to be a substitute for any civil action seeking monetary damages. So basically what that means is the vehicle owner is not barred from seeking money damages later, if warranted, based on the limited scope of this action. Sometimes we will see complaints from vehicle owners who want to have a whole discussion over the negligence of the tow company in towing the vehicle, or maybe damage that was done to the vehicle during the tow. They don't even know about some of that damage until they get the vehicle back. And so we want to make it clear that they're not barred from bringing that type of an action in a subsequent matter, but that this action is only about the possession. Additionally, Section 1 adds some clarification as to the timing of the claim and the proper named defendants, which is a constant issue that we see in the justice courts. One issue that we see is that cases are filed when the vehicle owner has already recovered the vehicle. And like I said, they're usually filing some sort of claim for loss of use or things like that that need a full-blown civil action. This particular expedited remedy is not the place for that. That's what Section 1 also clarifies. They can still bring that action at a later point, but not in this proceeding because of its expedited nature. We also see cases where the individual waits months. I can't explain why, but sometimes they wait months to file this type of a case. And because it's expedited, it is disruptive to the court to have to jump through hoops to set a case in such a quick fashion, only to have the parties come and find out that the vehicle's been there for months. In those situations, it is most often the case that the storage lien has already been put on that vehicle, and the vehicle has already been auctioned by the storage facility. At that point, the court does not have the ability to undo all of those other legal actions that have already taken place in order to determine whether the vehicle was lawfully or unlawfully towed and order it to be returned. So there's no remedy that the court could provide to a person who waits until they file this case. They might have an action for civil damages, as I stated previously, but this expedited hearing can never result in the court issuing an order for somebody to return the car if it's already been sold. This bill clarifies that the complaint should be brought within 21 calendar days. That timeline was designed to kind of make sure that that claim was brought before such a time of auction or lien would be acted upon. This section also clarifies the necessary parties to resolve the claim. It is necessary for the court to resolve the claim to have both the property owner who authorized the tow of the vehicle from their property and the tow company that towed the vehicle. Usually we see they only sue the tow company, and the tow company is not the one who authorized the tow. So we end up with only part of the story. Vice versa, if we only see the property owner, like an apartment complex, without the tow company that may have performed the tow and to know why they performed the tow, we're left with not an adequate amount of information. Because we want to resolve this case in that first hearing, in that only hearing, quite frankly, we don't want to be forced to have to continue it out yet another 4, 6, 7 days in order to resolve it. That only leaves that vehicle owner out that vehicle for a longer period of time should we determine it was unlawfully towed. So we want to make it really clear up front who they should name in the complaint. I will tell you right now, it is probably 90% of the time we have to continue these because the proper parties aren't named. So it really would provide some much needed clarity. Paragraph 3 gives the court the authority to dismiss the complaints that just don't meet these requirements so that we are not forced to have that hearing only to tell the parties, I'm sorry, we can't take any action. For example, a good example of that is when a law enforcement entity tows a vehicle. That's not the kind of case that is subject to the jurisdiction under Chapter 487. That would be a different action. So we get those periodically as well when law enforcement tows a vehicle as a result of either an arrest or an investigation of some sort. Paragraph 4 makes no substantive changes, but aligns the setting of a case to calendar days, 7 calendar days versus working days, to align and be consistent with the Nevada Rules of Civil Procedure. Paragraph 5 makes clarifying language that the court's order is one that declares who's liable for the costs of storage and declares whether the vehicle is lawfully or unlawfully towed, rather than any sort of a money judgment, which is not the result of this type of action. Paragraph 6 requires the vehicle owner, upon prevailing in this type of an action, to present a certified copy of the order to the storage facility that's holding their vehicle. One of the things that we got a lot of feedback on from the tow companies in working through these issues was that if they don't get a certified copy from the court, they have to take the extra time to try to verify it, and sometimes contacting the court and getting that verification can delay the return of that vehicle to the owner. And that's not what we're trying to accomplish here. We're trying to have this be an expedited process. That certified copy of the court's order can be provided to the litigant at the time of the hearing so that they can walk out of the courtroom with that certified copy to take to the storage company with them. That should result in no delay in them getting that vehicle returned when warranted. Finally, paragraph 7 of the bill was not part of the court's initial language in this bill, but it was amended in the assembly by Assemblyman Miller. It was the intent at the time to have the registered owner noticed of the tow within a fairly short period of time. However, I've subsequently learned that there were issues with the tow company's ability to access the information on the registered owner from the DMV within the time frame allotted. I believe there's someone on the call today who's going to speak to an amendment to strike that language, but to keep the portion that the storage company must post and have displayed information about services from Program for Legal Aid or the Civil Law Self-Help Center to help those individuals file their claims when necessary. So from my perspective, I have no objection at all to the amendment that is offered. I expect they will speak to their conversations with Assemblyman Miller. It is my understanding that he had no objection to striking that language and accepting the amendment as well. But I'll let others speak to that, and I'm happy to answer any questions.
All right, thank you so much for that presentation and for being with us today. I have a question about subsection 3, which is the piece about dismissing the complaint. Currently, it states that the court must dismiss the complaint. Is there any particular reason why that's a must as opposed to a may dismiss the complaint? It seems this kind of forecloses the ability for someone to file an amended complaint to cure any deficiencies.
I don't know that there is any particular reason for that language other than if it doesn't meet. I'm not sure there are deficiencies that we're thinking of. So for example, if it's more than 21 days after the tow, that's not something that could be cured by an amended complaint. If they don't have the proper people noticed, you are correct, that could be amended to add the right litigants on. It's typically the thought process was that if it names, say, Metro as the defendant, and that we know that's not a proper case for this type of action, or the timeline that it's more than the 21 days, then we would dismiss it. But I have really no objection to it being a may. I mean, the court can always exercise its discretion, and in those situations where maybe they've named the property owner but not the tow company, that we could alert them to that issue and they can amend.
Okay, thank you for that clarification. For the record, I want to note Senator Pickard has arrived and that we have Senator Spearman now on video. And so you, although it may not appear like it, have a full committee before you. Are there any questions from members? All right, looks like you're getting off easy. If we could have a representative from the Nevada, is it the Nevada Tow Association? Tow Operators of Northern Nevada, come and speak to the amendment at this time, that'd be great.
Thank you, Chair Harris. I was originally going to come up in support, but this is fine as well. Thank you, Judge Zaragoza, for your description of the bill. So the amendment discussed, like you said, strikes the language that was amended in the work session on the Assembly side and replaces it with language that fulfills, I believe, the intent, which is to ensure that those who are wrongfully towed or in need of resources have the means to find that information available, which is what is explained, displaying conspicuously a statement regarding the availability of assistance from a program for legal aid, self-help center operated or overseen by a court or other similar program in the city or county in which the facility or other location is located. So again, we believe it fulfills the intent, but removes the 24-hour requirement, which really was the heartburn. The tow operators, tow companies rely on the DMV to provide the contact information through registration records, and that turnover time is usually around 3 to 10 days. So the 24-hour requirement was essentially infeasible.
Senator Pickard.
Thank you, Madam Chair. Just a quick question. I think you said that this is striking out language that the Assembly put back or put in. If we're undoing what they did, is there any expectation that they're going to concur on this?
So the amendment on the, Maggie O'Flaherty, for the record, I apologize, with the tow operators of Northern Nevada. The amendment that was added in on the assembly side, Mr. Pickard, through you, through Chair Harris to you, Senator Pickard. It was brought forward by Assemblyman Miller, and we have worked with him throughout this process, and he has been incredibly collaborative with us in reaching a middle ground, and I believe that there's consensus.
Okay, good, thank you.
Can I just ask one quick question? And Assemblyman Miller's giving us the thumbs up for the official transcript. How do you envision this notice requirement being satisfied? So could I, take a 8x11 and write down legal aid's number on it and stick it on a window? Or is there some effort to maybe come up with some uniform disclosure that could maybe be shared amongst tow operators? How do you envision that actually working in practice?
Absolutely. Maggie O'Flaherty, for the record, haven't done this in person for a while, so I'm getting back used to it. Currently, there are a number of notification requirements that tow operators, tow companies are required to fulfill, and typically those are done through a uniform system through the NTA. So while it's not delineated in language here, we would be open to discussing something that's uniform and across the board. But typically, they defer to the NTA on notification requirements like this one.
All right, any additional questions? Okay, seeing none, we'll go ahead and open this up for testimony in support of AB 32. Is there anyone in the room who'd like to testify in support? Seeing none, BPS, if you could, actually, do we have anybody on Zoom who wanted to testify in support of AB 32?
Thank you, Chair Harris. My name is Sophia Romero. I'm a staff attorney with Legal Aid Center of Southern Nevada and the Consumer Rights Project. And I just wanted to put on the record that we are in full support of this bill. Thank you.
All right, thank you. BPS, if we could go ahead and turn to the phone lines to see if there's anyone on the phone who'd like to testify in support.
Thank you, Chair. Callers, if you'd like to testify in support of Assembly Bill 32, please press star 9 now to enter the queue. Will the caller with the last 3 digits of 580 please state and spell your name for the record? You may begin.
Good afternoon. For the record, I'm Paul Enos, E-N-O-S. I am the CEO of the Nevada Trucking Association. Chair Harris, members of the committee, speaking today in favor of Assembly Bill 32. First, would like to thank Judge Zaragoza and Assemblyman Miller for being collaborative on this bill and helping us address a number of these issues. We do feel like this is a process that will be streamlined, where we're getting both the tow operator and the property owner who has to put that request in for a tow before that tow is done. Having everybody in the mix is a good thing, and we do feel like this will streamline that process and result in a faster time where an individual can get their vehicle back. Thank you very much.
If there are any additional callers who would like to provide testimony in support of AB 32, please press star 9 now to enter the queue. Chair Harris, at this time, there are no additional callers wishing to testify in support.
Okay, is there anyone in the room who'd like to testify in opposition to AB 32? Not seeing any. Anyone on the Zoom who'd like to testify in opposition to AB 32? Go ahead and turn your camera on, make yourself known. Okay, it doesn't look like there is any. BPS, could you poll the line, see if there's anyone who'd like to testify in opposition?
Certainly, Chair. Callers, if you would like to testify in opposition to Assembly Bill 32, please press star 9 now to enter your place to the queue. Once again, if you'd like to testify in opposition to Assembly Bill 32, please press star 9. Chair Harris, at this time, there are no callers wishing to testify in opposition to the bill.
All right, thank you. Anyone in the room who'd like to testify in the neutral position? Okay. Anyone on the Zoom who'd like to testify in the neutral position? All right, let's go ahead and see if there's anyone on the phone who'd like to testify in the neutral position on AB 32.
Callers, if you would like to provide testimony in the neutral position for Assembly Bill 32, please press star 9 now to enter the queue. Once again, callers, if you would like to provide neutral testimony on AB 32, please press star 9 now. Chair Harris, the public line is open and working. However, no callers have indicated that they would like to provide neutral testimony.
All right, we'll go ahead and close out testimony on AB 32, and I'll kick it back to you, Judge Saragosa, if you'd like to make any closing comments.
Thank you, Chair Harris. My only closing comment would be I was just taking a closer look at the bill, and the only thing I would point out is in that paragraph 3 that you were questioning about earlier, that although it is a must dismiss, it is without prejudice against the complainant to refile should they need to. I realize that doesn't address the amended issue, but it does allow them to refile if necessary. I just want to point that out. Otherwise, I have no further comments. Thank you very much for your time this afternoon.
All right, thank you so much. We'll close the hearing on AB 32 and move right along to our next order of business, which is a hearing on AB 281. We'll open the hearing on AB 281, and I'll welcome Mr. Matt Walker to the table. Welcome, Mr. Walker. You can go ahead and begin when you are ready.
Thank you, Madam Chair and committee members. Matt Walker, for the record, here on behalf of Enterprise, and pleased to be with you this afternoon to present Assembly Bill 281, which revises provisions governing the retention of certain records by short-term lessors, brokers, and dealers of vehicles. Assembly Bill 281 would enable short-term lessors and car dealers to store data and records digitally while ensuring access to those records by regulators is made timely and providing greater protections for consumers of that data. If passed, the bill would increase security for consumers and businesses by not having those physical records stored at each rental location or car sale location. A company can secure, centralize, and digitize those records. Additionally, it would increase efficiency for regulators at the DMV, Department of Taxation, and local governments by allowing them, when they don't feel like making that in-person visit, to request those records, to be able to request those records digitally and obtain them in some cases a little bit faster. Very quickly, the bill, Section 1, Subsection 1 and 2 of AB 281 would allow for short-term rental records to be stored electronically and ensure regulators have timely access to those records. Section 2 similarly allows for car dealers to store records electronically. I would like to note that dealerships are not required to store records in this manner. This is simply enabling legislation that allows for the Department of Taxation, businesses, and other regulators to follow best practice for data security and increase efficiency when reviewing licensee records. So if there's that dealership in Ely that really likes their paper and wants to keep their filing cabinet, there's nothing in this bill that would require them to transition. With me today is, in Las Vegas, is Keith Duffy. He's the risk manager for Enterprise Rent-A-Car in Nevada. So he does the risk management not only for the Enterprise rental car locations that many of you are familiar with, but also the network of used car dealerships that Enterprise operates in the state. So he's got good experience with how this bill might manifest itself and be more efficient for Enterprise. And I'd like to kick it over to Keith to see if he has anything he'd like to add in terms of how he sees this bill playing out and how the current requirement for physical records is an impediment to the business. Thank you.
Hi, thank you today. Keith Duffy, for the record, with Enterprise Rent-A-Car. Thank you, Chair Harris and members of the committee for having me. So really, we've just looked at this in the past. We've had just trying to make sure we can store our records without having large rooms at our locations and just be able to quickly access these without going through file cabinets and have more data security online versus have a physical location that someone could break into and get into these records. So that's really just the goal of this, is just kind of simplify it and secure it instead of just having the paper files in one location. So there's not an overflow of documents in these buildings.
All right, thank you so much, Mr. Duffy. Does that conclude your presentation, Mr. Walker?
Chair Harris, Matt Walker for the record on behalf of Enterprise. I would just like to thank DMV, Department of Tax, local governments, franchise auto dealers, everybody who chimed in and added their viewpoint to the construction of this bill, and think it's a stronger measure as a result.
All right, are there any questions from committee members? Okay, I have just one. What is the record retention policy, and does this bill affect that at all? So theoretically, I don't know what the existing state of the law is, but let's say theoretically they require you to maintain a record in paper for 7 years. Is the timeline still going to be the same, or would this adjust that at all?
Keith Duffy for the record, Chair Harris. Yes, there's no changes in the timelines. Right now, it's between 7 and 10 years, depending on what documents that are needed to be stored. So if you have 7 years of a lot of automobile records or files, it can make for a file handling issue. So that's so no change in the time. So just more in the way of doing it.
Matt Walker for the record, Chair, if I may. The records retention timeline for the dealerships is slightly different at 3 years, but I would echo Mr. Duffy's comments regarding there being no change to those policies.
All right, seeing no additional questions, we will move to testimony. Is there anyone in the room who'd like to testify in support of AB 281? Go ahead and state your name and spell it if you can for the record, and begin when you're ready.
Good afternoon, Madam Chair, members of the committee. For the record, this is Andrew McKay, A-N-D-R-E-W, M-A-C-K-A-Y. I am the Executive Director of the Nevada Franchise Auto Dealers Association. First, I'd like to begin by thanking Assemblyman Miller as well as Mr. Walker and Enterprise for bringing this forward. This is much needed and welcome legislation. As the committee is aware of, we have a very paper-intensive industry, and as we continue to advance and move forward in the future and trying to electrify/digitize everything, this makes that happen. To respond briefly to what Mr. Walker said, yes, it is optional, but I don't know of one dealership that's not going to jump in to the deep end on this thing and move forward on it. So we just want to thank everybody for moving forward and involving us in the process. And Madam Chair, thanks for your time, and members of the committee. Appreciate it.
All right, thank you so much. Anyone else in the room would like to testify in support of AB 281? All right, seeing none, is there anyone on the Zoom call who'd like to testify in support of AB 281? All right, I don't see anybody virtually jumping up and down, so we'll go ahead and go to the phone lines. BPS, could you open up the phone lines, see if there's anyone who'd like to testify in support?
Thank you, Chair. Callers, if you'd like to testify in support of Assembly Bill 281, please press *9 now to enter the queue. Once again, callers, if you'd like to testify in support of Assembly Bill 281, please press *9 now to enter the queue. Chair Harris, at this time, no callers have indicated that they would like to testify in support.
Is there anyone in the room who'd like to testify in opposition to Assembly Bill 281? Seeing none, is there anyone on the Zoom who'd like to testify in opposition? All right, I don't see anyone. BPS, if you could pull the line for those who'd like to testify in opposition to Assembly Bill 281.
Callers, if you'd like to testify in opposition to Assembly Bill 281, please press star 9 now to enter the queue. Once again, if you'd like to testify in opposition to Assembly Bill 281, please press star 9 now. Chair Harris, at this time, no callers have indicated that they would like to testify in opposition to Assembly Bill 281.
All right, we'll do this one last time. Anybody in the room who'd like to testify in the neutral position? Okay, I don't see anybody. Anyone on the Zoom who'd like to testify in the neutral position? Also not seeing anyone. Let's see if there's anyone on the line who'd like to testify in the neutral position.
Callers, if you would like to testify in a neutral position for Assembly Bill 281, please press star 9 now to enter the queue. Once again, to testify in a neutral position for AB 281, please press star 9 now. Chair Harris, the public line is open and working. However, no callers would like to testify in a neutral position.
Okay, we'll close out the testimony then. Mr. Walker, would you like to make any closing comments, or are you feeling pretty good? Okay, we'll close out the hearing on AB 281 and open the hearing on AB 301, which revises provisions governing the towing of motor vehicles. And we'll welcome Assemblyman Miller to the committee. Go ahead and start when you are ready.
All right. Thank you, Chair Harris and Vice Chair Brooks and members of the committee. For the record, I am Assemblyman C.H. Miller, representing Assembly District 7 within Clark County. And this time I'm here to present Assembly Bill 301 in its first reprint for your committee's consideration. Now, as we all know, the COVID-19 pandemic dealt a sharp blow to our state's ability to conduct the business of government as usual. Agencies were required to cease in-person transactions and move to remote work environments with very little notice as a matter of public health and safety. And while Nevada quickly authorized the exhaustion of rainy day funds from the account to stabilize the operation of state government, the federal government moved to swiftly get financial assistance to Americans to help us all keep our families afloat. Now, in many cases, households that were already struggling due to strained budgets now had no option but to operate on less. And even though most were eligible for unemployment benefits, we as legislators know all too well how the department struggled to get those to many people who needed them. Now, like many Americans, a significant number of Nevadans found themselves in lines at various pop-up food banks, picking up boxes of food they could no longer afford to purchase, and so on. And it was almost a requirement to have a vehicle to even get the food if you really needed it. Now, imagine if we found ourselves here again, but someone's vehicle had been towed in the wee hours of the morning on the day they were there to pick up their 25-pound box of food. Operations at the Department of Motor Vehicles were no exception to the disruption. Staff from DMV have previously described the challenges the department faced during the past year to this committee. I'm sure to this committee as well. Challenges which the DMV has since adapted to and overcome. But there were still some issues, as it relates to our vehicle registration stickers. Under existing law, vehicle registration stickers are vehicle registrations are denoted by a license plate decal on, or more commonly referred to as a sticker, which is the term I'll use from now on. Those stickers show the month and year that a vehicle is currently registered, and it's an indication of if a vehicle has current registration or not. However, due to the pandemic and what we were dealing with, many of those stickers were not mailed out or received in a timely manner, and vehicles were currently registered but didn't have the sticker to display. And so what ended up happening was these vehicles were beginning to get towed, even though they had current registration. And the reason for that tow was the fact that the sticker was not current and the registration appeared to not be current. It became such an issue that the NTA, the Nevada Transportation Authority, issued a letter notifying tow car operators that the agency had become aware of the practice and issued the following directive that I will just briefly quote from. To ensure vehicles being towed as unregistered are in fact unregistered, the NTA is requesting that tow companies verify the registration status of the vehicles in question via the Nevada DMV's website prior to towing a vehicle as unregistered. This bill, AB 301, will codify this directive into statute and will require tow car operators to release the vehicle without charge to the owner if the owner is able to provide proof the vehicle was indeed registered at the time of the tow. Tow car operators are able to verify the vehicle owner's claim in real time using the link to the DMV's website. They're also able to use this link before they make a tow, just to ensure that the vehicle is in fact not registered at the time of the tow. So this should completely remove the guesswork out of whether or not a vehicle is eligible for tow based on its registration status. But let's face it, mistakes happen. And when they do, vehicle owners who now have to take a portion out of their day and incur an additional transportation expense to travel down to the tow yard just to pick up their vehicle that may have been towed mistakenly, this bill will now require the tow operator to release the vehicle immediately if that is the case. It also extends the time that the tow operator can pick up the car from notification until actual towing if the vehicle is parked in a designated parking space. It changes that time from 48 hours to 5 days, and it doesn't allow for vehicles to be charged a storage fee until the vehicle has been on the yard for 48 hours instead of the current 24 hours. As you know, if you get your vehicle towed and if you don't have the money to get it, it may be very difficult to come up with the money to get it released immediately. And so giving that additional time for some Nevadans who are, having some hard financial times, which is probably an indication as to why their vehicle registration is not current in the first place, gives them some additional time to remedy their situation and properly find the funds to do so. I'm going to go ahead and turn the walkthrough of the bill over to Sophia Romero, who's been helpful in this process. And I'd just like to acknowledge that the tow operators have been very helpful as well in helping me to find solutions and even suggesting language that makes the bill work for all of us while providing additional protections for those who are having a hard time. So, Chair, with your permission, I'd like to turn the remainder of the presentation over to Ms. Sophia Romero from the Legal Aid Center of Southern Nevada. And once she is finished, we will be ready for questions. I believe I have Commissioner David Newton from the Nevada Transportation Authority available on Zoom to answer questions as well. Thank you.
Ms. Romero, happy to have you here. I'd be remiss in not mentioning that we used to work together, and it's a pleasure to be just in the same space with you again, because you're always doing great things. So thanks for bringing that energy here to the legislature. Go ahead and begin when you're ready.
Thank you, Chair Harris. I appreciate it, and it's great to see you too. Good afternoon, Chair Harris, Vice Chair Brooks, members of the committee. For the record, my name is Sophia Romero, and as Assemblyman Miller stated, I am a staff attorney in the Consumer Rights Project at Legal Aid Center of Southern Nevada. Before I walk through the bill, I would like to thank Assemblyman Miller for bringing this very important piece of legislation. This will be a much needed addition to Nevada law and solves a problem we've seen quite a bit. We are all subject to having our vehicle towed, whether it be by our HOA, apartment complex, or even parking in the wrong spot at the wrong time. For some, when this occurs, it's a minor inconvenience and makes for a bad day. However, for others, it can be what sends them into extreme financial hardship. Not having a vehicle to get to work can result in the loss of employment or turning to alternate methods such as payday loans to try to obtain emergency funds. Working at legal aid, I've become accustomed to having an unusual caseload. We are often people's last resort. The week before AB 301 was introduced, an applicant called seeking assistance because his car had been towed for lack of registration. This happened despite the fact that his registration was current. He filed a complaint for unlawful tow in court, showed his proof of registration at the hearing, and still lost. All because his decal was not current and despite the directive of the Nevada Transportation Authority. Unfortunately, without any knowledge of the November 2020 NTA letter or this pending legislation, we were forced to decline him in representing him in an appeal. It is extremely rare that we decline representation, but even I felt hopeless when presented with his situation. It is because of this case that I was so excited when I read AB 301 and why we were so eager to reach out to Assemblyman Miller and ask if we could help support his bill. I urge this committee to support it as well. Now I will walk through the bill. Section 1 of the bill states that if a vehicle owner or their agent provides proof that the vehicle was registered at the time of the tow to a tow car operator, the vehicle must be released to them without charge and states that a proof can be either physical or electronic format. Section 2, which is essentially the meat of the bill, states that the owner of the real property must notify the vehicle owner of the tow at least 5 days before the tow by placing a sticker on the window of the vehicle. That sticker must provide the date and time after which the vehicle may be towed. The real property owner must also attempt to notify the vehicle via telephone or email if available, and shall affix the notice to the door of the residential unit when the vehicle is in an assigned or designated parking space. There is an exception to the notice requirements if the notice was already given for the same or similar reason, or if the vehicle has been towed more than 3 times in the preceding 6 months. Section 2 also requires tow car operators to independently verify the registration status of the vehicle by using the DMV's website before towing the vehicle and keep evidence of this verification for 1 year. Any tow car operator who fails to comply with this requirement is responsible for the vehicle's removal and storage costs. Again, if the vehicle was registered at the time of the tow, either in Nevada or any other state, then the vehicle must be immediately released to the owner without charge. Additionally, Section 2 states that a tow operator shall not charge a storage fee unless the vehicle has been on the property for 48 hours, and that time period starts during business hours. So if the vehicle is towed in the middle of the night, the 48-hour period would not start until business hours the next morning to allow a person actually 48 hours of real time when they can actually take care of the situation. If the registered owner does not provide proof that the vehicle was registered at the time of the tow, but they are incapable of paying the normal rate for the removal and storage of the vehicle, then they shall pay a hardship tariff for that cost. The hardship tariff shall be established by the Nevada Transportation Authority, which will have authority to adopt regulations to carry out its provisions. With that, I will conclude. I am available for any questions the committee may have, and I will turn it back over to Assemblyman Miller. Thank you.
All right, thank you so much for that walkthrough, Ms. Romero. Are there any questions from committee members? All right, Senator Hammond, and I know Senator Spearman has a question as well. We'll go to Senator Hammond first, and then I'll shoot it to you, Senator Spearman.
Thank you, Madam Chair. And I was just looking at this section here, and I didn't write it down, so give me just a second. I think it's section 2. Subsection 3, well, basically the part that says that they can go ahead and tow the vehicle if there's a similar reason within the same residential complex 3 or more times during the immediately preceding 6 months. I guess for the NTA, I think you had David Newton on the phone. Is that something that they monitor, that they can actually tell you if that person has been cited, and they keep a track of that kind of stuff? And so this would actually apply to it?
Thank you for the question, Assemblyman C.H. Miller. For the record, I will defer to Commissioner Newton for that answer if he has it.
Oh, and before he does answer, I think I better disclose. I guess I'd be remiss if I didn't tell everybody that we did work together quite a bit. David Newton and I used to share an office together. He brings this kind of really good energy also to everything that he touches. So I just want to make sure everybody knew that in case there's any confusion. Go ahead, Mr. Newton.
Doesn't look like he's on. That's okay, Senator Hammond. It's not your first joke to fall flat. It's fine.
No kidding, I tell you what. After all that, his energy is so brilliant that he left this planet for a little while and will return later on. He's probably off listening to Neil Diamond somewhere.
Assemblyman C.H. Miller, for the record, Senator Hammond, I will directly get that information to you and sent out to the committee.
Appreciate it,
Whether
thank
or
you.
not they are currently tracking. But as I think through some of the conversations that I have had, because in order for them to make the initial tow, it has to be given the green light by the property owner. So I would assume that there is a record that they are keeping of each time that they authorize the tow. So whether it be the property owner or the tow operator themselves, I'm pretty sure there's a record of that.
And the reason for me asking, again, thank you very much for the answer, is, you don't want to overburden somebody, right? And I guess if it becomes, this is something that they do, and they do quite often anyway, they have a record of it, it's not an additional burden, it just seems reasonable to me. But I just wanted to check and see what they thought. Thank you.
Senator Spearman.
Thank you, Madam Chair. So I just have a couple of questions. I guess the first one, I'll start with, pick up on where my colleague, Senator Hammond, just left off. Keeping a record, I would hope that they would. Is there no way that we can verify that they are keeping a record? And if so, what does the record contain?
Thank you for the question, Senator Spearman. It's C.H. Miller for the record. I will confirm and get to the committee exactly what type of records they're currently keeping.
Thank you. And I think that's important because I've heard from several of my constituents during the pandemic when DMV was closed, and it was clearly acknowledged that there would be a grace period for people either renewing the license plates, the registration, or what have you. And so they were not to get a ticket, but people, tow companies were coming into apartment complexes towing their cars. One person I heard from had to borrow, did I tell you they had to borrow? Yeah, they had to borrow $2,000 to get their car back, and they had just been laid off. So I'm concerned about, number one, where the tow operators are going. I'd like to know that information by zip code, and would also like to know what kind of record are they keeping and the average cost, because during a pandemic when people are unemployed or just had their hours reduced, I'm gobsmacked as to why anyone would take someone's car and then it'd be $2,000 to get it back. So that's the other thing that I like to ask. And is it possible at all to add an amendment to that would require them to keep a record, and the record must include the cost of towing and the cost of storage? In other words, how much is it going to cost a person? How much did it cost a person to get their car back? And the zip code from where they towed the vehicle. Just a question, and I hope that you'll see that as a friendly amendment.
Thank you, Senator Spearman. It's C.H. Miller for the record. So I am certainly open to exploring that with the tow operators to see how we can, and with the NTA to see how we can, what data we can collect, and how we can make that happen. So thank you.
No, thank you. And one last comment, Madam Chair, if you will indulge me. Many times when you ask for this type of information, the first thing that people say is it's going to be too onerous, we cannot do it. And I would believe that if we had the same system in place that Bob Cratchit sitting over a tablet with a stubby little pencil, or Fred Flintstone trying to carve it into a rock, but we have technology now, and the only thing we're talking about here are just adding columns to the data collection that they already have. And I think this is going to be very important because we need to know where the cars are being towed. We need to know the socioeconomic status of the people whose cars are being towed. I will not make any accusations, but I'll just say this should be something that should be easily accomplished. And if their record keeper cannot accomplish it, then we probably need to add something to the legislation that will advise them where they can get a computer program that will do that in less than 3 nanoseconds. So that's all.
All right, any other questions from members? Okay, not seeing any, we will go ahead and move to testimony. Is there anyone in person who'd like to testify on AB 301? Thank you so much, Mr. Miller. I encourage all in-person folks to follow his cleanly example.
Thank you, Chair Harris. Maggie O'Flaherty with McDonald Carano, for the record, here today on behalf of the tow operators of Northern Nevada.
Could you spell that one time for our secretary, please?
Yeah, absolutely can. Maggie, M-A-G-G-I-E, O'Flaherty, O''Flaherty. And again, here on behalf of the tow operators of Northern Nevada. This area, towing and immobilization of cars, can be very tricky at times, and the laws and rules that govern it can also be tricky, and it was certainly only exacerbated by the COVID pandemic and the hardships that it brought. So we are here today in support, surely because we appreciate the intent behind the legislation, but also because of the work that Assemblyman Miller has done to meet us in the middle, address our concerns, and get the bill to a place where we can support it. So we are appreciative of him for that. And if I may, Senator Spearman, we hear your concerns, and we will work with Assemblyman Miller, work with you, and do what we can to get the answers that you're looking for, and to continue to work in the interim and over the next sessions to address those concerns. Thank you.
All right, thank you. Is there anyone else in the room who'd like to testify in support? Looks like we have one. Welcome, Mr. Shepak.
Hello, thank you, Chair and committee members. My name is Nick Shepak, Nickshepak, Policy and Program Associate for the ACLU of Nevada. We're proud to be here in support of this bill. The ACLU would go as far as saying we should end the towing of cars for lack of registration completely. There's too many laws on the books in this state, as we have learned very well this session, that say if you're poor, then you're going to be punished with an inability to get to your job. And that's what towing somebody's car does if they can't pay the tow fee. Right? We do not have cities that have the best public transportation, especially in the rurals. We've seen this with traffic tickets, we see this with license suspensions, and now we see it with towing. And Senator Spearman is correct, when we are talking about who is the most likely to be towed, it is communities of color, it is lower income communities. That's where we see these cars being towed, and it is extremely difficult to pay. So this bill extending the time limit from 24 to 48 hours before you have to pay will help alleviate some of that pain. It'll allow people to collect some money, but it still is a difficult issue, and it's one we should continue to work on. This bill is a great first step and something we really can build on in the future, but we need to look at how towing impacts people. It's not the same if you live in Glenbrook up at Lake Tahoe, or if you live, by the airport in Reno. A tow means a major different thing to different people, and these reforms are modest, but we do think they will have a significant impact on individuals, and we urge your support on this bill. Thank you very much.
All right, thank you. Is there anyone on the Zoom who would like to testify in support? Not seeing anyone. BPS, if you could please pull the line to see if there's anyone who'd like to testify in support of AB 301.
Certainly, Chair. Callers, if you would like to testify in support of Assembly Bill 301, please press star 9 now to enter the queue. Will the caller with the last 3 digits of 580 please state and spell your name for the record? You may begin.
Good afternoon, Senator Harris, members of the committee. For the record, I'm Paul Enos, E-N-O-S. I am the CEO of the Nevada Trucking Association, and we also do have a number of tow operators as members of the association. We are here today to speak in favor of Senate Bill 301. Really, this is about a balance, trying to find a balance between the property owner and the vehicle owners. And really, it's the tow operator that is the agent to try to ensure that that balance exists. A lot of property owners, they don't want abandoned vehicles on their property, and that does tend to happen. And a lot of times those vehicles aren't registered. So we do feel like we keep moving in directions where we try to achieve more balance. We do think that this bill does help us achieve that balance between the property owner and the vehicle owner, with the tow operator acting under the regulations of the Nevada Transportation Authority. And, you know, this is really something that we have done over the 15 years I've been with the Nevada Trucking Association, making sure that you have a wet signature from a property owner before that vehicle is towed, that vehicle has to be, there has to be a specific request that vehicle is towed. So we do feel like this is just moving that balance a little more to make sure that we're towing vehicles properly, that people who are properly parked, that their vehicles aren't being towed. We do want to say thank you to Assemblyman Miller for working with us on this issue, and happy to work with the Nevada Transportation Authority and get some of the information that Senator Spearman has asked for, because that information does exist. We do keep records on where the vehicle was towed, when it gets to the lot, how much that storage was. It's all regulated by tariff at the Nevada Transportation Authority. So that data does exist. How difficult is it going to be to get from the NTA? That's a question that you're going to have to ask them. Thank you for your time.
Will the next caller with the last 3 digits of 000 please state and spell your name for the record? You may begin. Once again, caller with the last 3 digits of 000, please state and spell your name for the record. You may begin. Chair, it looks like that caller was having some technical difficulties. Would you like me to circle back to them later?
Yes, please.
Certainly, Chair. Callers, if you have just joined the call and would like to provide testimony in support of Assembly Bill 301, please press star 9 now to enter the queue. Chair Harris, no additional callers would like to give testimony in support. Would you like me to try the previous caller one more time?
Yes.
Will the caller with the last 3 digits of 000 please state and spell your name for the record? You may begin.
Oh, can you hear me?
Yes, we can. Please proceed.
Oh, great. My name is Commissioner George Assad. I'm with the Nevada Transportation Authority. I'm one of the commissioners here. Commissioner Newton is in the middle of an impound hearing, so he was unable to respond to Senator Hammond's questioning. And just for the record, I am in support of AB 301. I think it's a good bill. It certainly would be a benefit to the traveling public, and it would actually help the tow industry avoid issues as far as record keeping. The records are kept with the tow company, and the records should also be kept with the property owner or the legal representative of the property owner. The only time the NTA gets involved in any type of record-keeping issue is when there is a complaint brought to us by the owner of the vehicle. With that, if there are any questions, I'd be happy to answer.
Thank you so much, Commissioner. And I believe we do actually have Commissioner Newton on the Zoom at this point. And so, Senator Hammond, if you wanted to reconnect with your old friend, this would be the time.
There he is. Hey, old friend. See, look at that. Yeah, he actually acknowledges that he knows me. But you're too late. We actually got the answer to the question. I'm satisfied with the answer unless you wanted to add anything to it. Commissioner?
No, I would just like to express my apologies for having to step out for a moment. There was an impound hearing that got scheduled late yesterday, and I was processing that, and I apologize I had to step out.
No apologies needed, Commissioner. It's great to have you here. BPS, if we could go back to the line and see if there's anyone else who'd like to testify in support.
Certainly, Chair. Callers, if you would like to testify in support of AB 301, please press star 9 now to enter the queue. At this time, Chair, no additional callers would like to provide testimony in support of AB 301.
Okay, is there anybody here in the room who'd like to testify in opposition? Not seeing any. Is there anyone on the Zoom who'd like to testify in opposition? Go ahead and turn your camera on, make yourself known. All right, not seeing any. BPS, if you could poll the line.
Thank you, Chair. Callers, if you would like to testify in opposition to Assembly Bill 301, please press star 9 now to enter the queue. Once again, to testify in opposition to AB 301, please press star 9 now. Chair Harris, at this time, no callers have indicated that they would like to testify in opposition to the bill.
Okay, is there anybody in the room who'd like to testify in the neutral position? Not seeing any. Anyone on the Zoom want to testify in the neutral position? Again, not seeing any. BPS, is there anyone on the line who'd like to testify in the neutral position on AB 301?
Callers, if you would like to provide neutral testimony on AB 301, please press star 9 now to enter the queue. Will the caller with the last 3 digits of 490 please slowly state and spell your name for the record? You may begin.
Cyrus Hojati, Cyrus, Hojjaty. Good afternoon. We're very grateful to have Assemblyman Miller to bring up this bill. This situation is very important, and I have experienced many similar instances with towing. Unfortunately, I have not read the bill entirely, but we're very grateful that this issue is being brought forward. Thank you. Yield my time.
Chair Harris, at this time, there are no additional callers wishing to provide neutral testimony.
Okay, we'll close out the testimony then on AB 301. I'll kick it back to you, Assemblyman Miller, if you'd like to make any closing comments.
Thank you, Assemblyman Miller, C.H. Miller, for the record. I would just like to echo Senator Hammond's thoughts about Commissioner Newton. He was also a pleasure to work with, as well as the NTA staff. And outside of that, I thank you for your time and urge your support of the bill. Thank you.
All right, thank you. Don't go anywhere. We're going to close the hearing on AB 301 and open the hearing on AB 388, which revises provisions governing access to broadband services. And I will welcome you back to the committee. Assemblyman Miller, go ahead and begin when you're ready.
Thank you once again, Chair Harris and Vice Chair Brooks and the committee members. I am Assemblyman C.H. Miller. For the record, I represent the fine folks of Assembly District 7 in Clark County, and I'm here to present Assembly Bill 388 in its first reprint for your consideration today. Now, I'm sure you all know, as I mentioned previously, that the COVID-19 pandemic brought a lot of issues to the forefront. It brought into greater clarity the stark differences between different sectors of Nevada society. The disparities in broadband access and service provided another magnifying lens into those very serious differences. Last year, when schools had to go strictly online, the pandemic showed us just how large the digital divide was in our state and is. This term can be defined as the gulf between those who have ready access to computers and the internet and those who do not. Essentially, the haves and the have-nots. Now, we know that in the information age where we live today, which is also called the digital age, that access to reliable high-speed internet service is no longer optional, but is as essential as any other utility that we use: water, electricity, natural gas, and now internet. Furthermore, households that do not have ready access to reliable internet may suffer economic and educational setbacks like those that have been highlighted throughout the pandemic. And communities without proper infrastructure to accommodate high-speed internet may be economically left behind. As our state makes bold moves to advance our standing as a leader in technological advancements, we must do our best to ensure that no Nevadan is left behind due to a lack of inadequate internet accessibility, especially our youth, whose future will be increasingly dependent upon reliable, high-speed, high-quality internet in their homes and at their fingertips. So this is not just a problem for students who are negatively impacted by these issues. Many individuals working from home must make a schedule on who used the internet when, like back in the days when people had just one TV. Now, I know there are a few members in this committee that know exactly what I'm talking about. But this forced families that may have poor broadband service to make a schedule in order to not see interruptions or extreme lag times when needing to access telehealth services, or individuals wishing to safely attend worship services remotely or socialize with family and friends. Inadequate internet keeps people from fully participating in remote activities that are routine for those with decent internet connectivity. Like in historically low-wealth neighborhoods where infrastructure doesn't always support the best broadband service available, and in Nevada's more rural areas, the infrastructure required for broadband simply may not be available yet, or it will require a large capital investment to purchase right-of-ways and dig trenches for the installation of lines and such. Now, Nevada has made some progress as it relates to infrastructure and broadband access. We went from nearly 1 in 4 students not being connected to confirming that all Nevada students were connected in January. This is progress, but we still have a ways to go. And we hope that what will come out of the federal government in the near future will get us much closer to an always totally connected Nevada. But we can't wait on them. Our time to act is now, and we, Nevadans, must ensure that we have our own mechanism in place that is forward-thinking, can build on what we've done, and further supplement what we expect to receive, with a goal of not just closing the digital divide, but keeping it closed. Assembly Bill 388 in its first reprint seeks to do exactly that by inviting all Nevadans to take care of our own and ensure equitable, reliable internet access is available to every Nevadan, regardless of their zip code, neighborhood, or how close they are to a population center. So how do we do this? I'm glad you asked. We know that beginning May 12th, the federal government will begin accepting applications for the emergency broadband benefit, which will provide financially strapped households access to broadband services with $50 a month benefits to cover the cost. That only partially solves the problem in paying for it. As mentioned, we also have the issue of the service being decent enough quality that is actually usable, which requires infrastructure projects to not only catch us up, but keep us going. And so, in short, this is what AB 388 does. It requires the Public Utilities Commission of Nevada to enact regulations establishing a program enabling providers of broadband or radio service radio service, also known as wireless providers, to participate in a voluntary contribution program for broadband infrastructure. Again, I'll repeat that. It's a voluntary contribution program for broadband infrastructure. The program enables customers to opt in and round up their monthly bills to make voluntary contributions that will be distributed to the Office of Science, Innovation, and Technology to administer a program of infrastructure grants to support the expansion of broadband deployment in low-wealth neighborhoods and rural communities. Secondly, it requires OSIT to establish and administer a grant program where providers can apply for funds for the deployment of infrastructure projects that go toward installation and upgrades in low-wealth neighborhoods and rural communities. Third, it requires on at least a biennial basis that the director of OSIT must, one, collect and map data concerning broadband access speed in each county, and two, prepare and submit a report concerning the availability of broadband service in Nevada to the governor and the legislature. And four, it also requires OSIT to establish a broadband-ready community certification program to advance the expansion of broadband infrastructure to underserved communities and set forth provisions for this program. Now, I've had the pleasure of working with our broadband and wireless providers, as well as the PUCN and OSIT in the development of the bill in its first reprint. Now, as you all know, bills almost always remain a work in progress. And so there is a friendly amendment proposed by PUCN and OSIT that has been accepted. The amendment eliminates the use of a third-party administrator and eliminates the fiscal note. Chair, at this time, I would like to turn the presentation over to Debria Terwilliger from PUC and Director Mitchell of OSIT to discuss the amendments. And once they have finished, we will be ready for questions. Thank you.
All right, we'll start with you, Ms. Terwilliger, ladies first.
Thank you, Chair Harris. Appreciate it. And thank you, Assemblyman Miller, for bringing this important piece of legislation. And I actually was going to share my screen, if you would like, Chair Harris, just as I walked through the amendment, or I can just talk about it. It's your preference.
I have no preference.
Okay. I will share my screen here. I believe I'm sharing it now. Am I sharing it?
You are.
Okay.
Although we can't read it. So you may want to zoom a little bit if it's going to serve any actual function for the committee.
Can you read it now, or is it still too small?
No, that's much better. Thank you.
Okay. All right. Again, I wanted to thank Assemblyman Miller for bringing this important piece of legislation and letting us participate in the discussions about this AB 388. Debria Terwilliger for the record at the PUCN. So our amendments here, the colors are a little bit all over the map, but I will address each proposed amendment from us and OSIT, and Brian Mitchell is also available, and I'll let him speak when we get to the sections that are particularly relevant to him. So section 2, we've proposed in this amendment to delete the new definition of broadband service. There is a concern on the PUCN's behalf about defining broadband service in legislation. It's almost stale the moment you put it in, and we're proposing to take that out for now, but you'll see in a later portion that we're putting back in the old definition of broadband service that exists now, because that relates to our jurisdiction. And at this point, I'm sorry, I'm going to try to adjust my curtains here so I don't have a thing coming over my face. So we're going to leave the old definition of broadband service in Chapter 704 of the Nevada Revised Statutes, so that we don't have any jurisdictional issues and it doesn't change our jurisdiction at this time. So first amendment would be to delete the new definition of broadband service in section 2. The amendments now here to, all right, I'll try not to go too fast. The amendment now to section 3 changes how the commission collects the voluntary contribution program, or funds that come in through the voluntary contribution program. The current amendment 377 has those funds be administered by the independent administrator, which is the independent administrator for the Nevada Universal Service Fund. And we had concerns that if the independent administrator administered those funds, that might add to the cost and would reduce the amount of money available to flow to OSIT. So the commission determined that through its own processes, we could handle that money and make sure that money we get in from the providers who are voluntarily participating in the program. We can receive that, and then we can immediately deposit it with the state treasurer, and it does not have to go through the independent administrator. So all these things in red and blue you see here are to accomplish that goal. And same on section 3.5, this talks about the commission shall deposit that money with the state treasurer, and the treasurer will allocate that money to OSIT. So all those changes in blue and red are to accomplish that goal. The proposed amendment in section 4.5, this is a remnant, 4.5, this is a remnant from the original bill. It sought to rename the fund to maintain the availability of telecommunications service, which is the Nevada Universal Service Fund. We don't need to rename that. This came out of the separation of AB 388 from 377, and I don't think we need to do that. So that's why we're proposing to amend that renaming of definition. Obviously, NRS 704.013 will stay in statute as it is. This just deletes the amendment to that section of the statute. And then, as I discussed previously, the change here in subsection 4, we're putting back in the old definition of broadband service. I recognize that this definition of not less than 200 kilobits per second is very out of date and stale, but this section of the statute does relate to our jurisdiction. And so we put that definition back in so that doesn't change our jurisdiction at this point in terms of broadband service. Obviously, this AB 388 does tweak the PUC's jurisdiction a bit to the extent that a broadband provider does participate in the voluntary contribution program, but the changes in our jurisdiction are very limited to this program. And then I think the changes from here on out, I will let Director Mitchell go through because those all relate to his section of the statute, his chapter of the statute.
Director Mitchell.
Thank you, Madam Chair. Thank you, Madam Chair, and members of the committee. Brian Mitchell, Director of the Office of Science, Innovation, and Technology, for the record. And if I could summarize just briefly the changes that we're making, it's really to simplify the bill. There were a lot of changes that were made, and we realized that we could make things a lot simpler, which would mean more money in would go to infrastructure projects in the community. So in section 7, the 7.3 and 7.5 are being eliminated, in part due to the change that Ms. Terwilliger mentioned above about removing the updated definition of broadband service. And then if you continue to scroll down, and really this will make the transfer of funding a lot easier for the state, and there won't be as much money that is caught up in administrative costs. And then section 7.6, paragraphs 1 and 2, sub B and C were also eliminated as they are they're out of date and not necessary anymore with regard to how we are going about the bill at this point. So what OSID will do moving forward is we will still be preparing a report that has a summary of the availability of broadband services throughout the state, and also recommendations for the deployment of infrastructure to underserved communities. And we will submit that to both the legislature and the Legislative Council Bureau. And we believe that this language, as it reads now, is a lot cleaner, rather than inserting information about collecting and mapping speed levels. And so our source for this information will be Congress recently authorized the Federal Communications Commission to undertake a nationwide mapping program. And so we will, rather than doing this ourselves, we will use federal data from the FCC in order to prepare this report to you. And we believe this report will be very useful to the state to highlight areas where, as Assemblyman Miller mentioned, where we have good service and where we don't, and what we can do to improve that in our goal towards universal coverage. And then there were no further changes to the remainder of the bill. And I would be happy to answer any questions.
All right, thank you so much. Are there any questions for Assemblyman Miller or Mr. Williger or Director Mitchell? Okay, not seeing any. We will go ahead then and turn to testimony for AB 388. There is no one in the room at this point, so we will skip that exercise. Is there anyone on the Zoom who'd like to testify in support of AB 388? All right, not seeing any. BPS, if you could pull the line.
Thank you, Chair. Callers, if you'd like to testify in support of AB 388, please press star 9 now to enter the queue. Will the caller with the last 3 digits of 528 please state and spell your name for the record? You may begin.
Chair Harris, members of the committee. For the record, my name is Barry Gold, and I'm the Director of Government Relations for AARP Nevada. Although this bill is being heard today instead of yesterday, my testimony today is in honor of someone who was and still is in all of our memories a friend to us all, Assemblyman Tyrone Thompson. Access to high-speed internet broadband was an issue that was so important to him. So, let me take a breath here. Today, high-speed internet access, commonly referred to as broadband, is essential. It enables older adults to benefit fully from technologies that improve quality of life and allow them to age in place. This includes online applications that enable people to receive telehealth services, connect with friends and family, shop for groceries and other items, work from home, stream entertainment options, engage in lifelong learning activities, and more. Communities need the infrastructure to be able to offer high-speed infrastructure. Yet, availability is lacking in many parts of the country, particularly many lower income and rural areas. Further, the service must have the capacity to support current and future needs. The provisions of this bill will enable the Public Utilities Commission and the Governor's Office to address the problem and provide incentives through grants for infrastructure, specifically for low-income rural areas, as well as look at broadband availability and speed across the state. Addressing the digital divide requires a commitment to digital equity. That is, everyone, regardless of factors such as age, race, ethnicity, income level, and geography, should have access to affordable, reliable, high-speed internet service. So AARP Nevada, on behalf of the 345,000 members across the state, support AB 388 and urge the committee to pass it to improve access to broadband services for Nevada families across our state. Thank you.
Will the next caller with the last 3 digits of 938 please state and spell your name for the record? You may begin.
Good afternoon, Chair Harris, Vice Chair Brooks, and members of the committee. For the record, my name is Ariel Edwards, ARIELLE-EDWARDS, on behalf of the City of North Las Vegas. Quality broadband is essential and provides communities with access to health care, employment opportunities, education, and more. It was unfortunate to see many children here in North Las Vegas during the pandemic attend school outside on a sidewalk by a bus that was providing high-speed internet. Assembly Bill 388 is much needed in ensuring that infrastructure is built to increase accessibility to broadband in communities. Therefore, we are in strong support of Assembly Bill 388 and want to thank Assemblyman Miller for his work on this important piece of legislation and for bringing it forward. We urge its support and passage. Thank you.
Will the next caller with the last three digits of 601 please state and spell your name for the record? You may begin.
Good afternoon, Chair Harris and committee members. My name is Barbara Paulson, BARBARAPAULSEN, and I'm speaking today on behalf of Nevada's for the Common Good. As you've already heard, everything from applying for a job, renting a place to live, filling out a loan application, to during this pandemic, trying to get rental assistance or unemployment insurance, all depends on the internet. Over the last several months, Nevadans for the Common Good has talked with numerous parents in our Hispanic community whose children are attempting to participate in online education. The broadband infrastructure in their neighborhoods is often insufficient to support 2 or more students online simultaneously. Parents, in fact, are receiving truancy notices from the school district, not because their child is skipping school, but because that child can't get online or is having to divide the day up among several children in order to get their education. All of this means that many residents in older, dense urban areas or rural parts of the state often lose video and/or audio connections while conducting necessary business because they have difficulty securing stable and reliable internet access. We are very pleased to see Assembly Miller bringing this bill forward. We think it is exciting and creative, and we are especially pleased that the bill will have a component to it where we can collect data so that we can see what our need is and how that need is changing over time and stay, as he said, on top of the issue. Nevadans for the Common Good stands strongly in support of this bill, and we hope you vote yes on it. Thank you for your time.
Are there any additional callers who would like to provide testimony in support of AB 388? Please press *9 now to enter the queue. Chair Harris, at this time, no additional callers have indicated that they would like to testify in support.
Thank you. Let's move on to those who'd like to testify in opposition to Assembly Bill 388.
Callers, if you would like to testify in opposition to Assembly Bill 388, please press *9 now to enter the queue. Will the caller with the last three digits of 969 please try to press *6 to unmute yourself? Thank you, caller. Please state and spell your name for the record. You may begin.
Good afternoon, members of the committee. Chair Harris, my name is Brian Wachter, BRYANWACHTER, on behalf of the Retail Association of Nevada. First, we'd like to thank Assemblyman Miller for bringing the bill and bringing very much needed attention to broadband infrastructure, and access here in Nevada. We would like to register our opposition to the bill. We do believe that 388, while well-intentioned, is unnecessary for several reasons. The federal government, through Congress and President Biden, have provided $5 trillion of help to the economy in direct economic stimulus payments, with the intent for those who received those to be able to engage in current market conditions without the need for government intervention. The federal government has also allocated $4 billion to Nevada specifically for broadband deployment in the state. And then next week, as you heard, the FCC will begin taking applications for the emergency broadband benefit, which is a $3.2 billion program that 40 broadband providers, here in Nevada, have signed up to participate in the program. Many of our broadband providers in Nevada already offer products to qualifying households, some as low as $5 to $10 per month. And again, these are currently using no taxpayer or government subsidies. We have concerns that the contribution program contemplated may actually cost more to administer than the program generates. And we believe that the federal government study that was recently authorized is going to give us all the information that we need in order to be able to combat this problem as a state. For those reasons, we applaud the goal, and we look forward to watching as the federal government programs wind their way to Nevada and are able to provide these services to our citizens so they can participate in those everyday activities. And we appreciate your time and urge you to vote no on 388.
Thank you, caller. If there are any additional callers who just joined us, we are on opposition for Assembly Bill 388. If you would like to provide testimony in opposition, please press *9 now to enter the queue. Chair Harris, at this time, there were no additional callers wishing to provide testimony in opposition to the bill.
All right, thank you so much. Let's move to the neutral position.
Callers, if you would like to provide neutral testimony for Assembly Bill 388, please press *9 now to enter the queue. Will the caller with the last 3 digits of 490 please state and spell your name for the record? You may begin.
My name is Cyrus Hojati, Cyrus Hojjaty. We understand it's very, very important to increase broadband access, and there's a lot of people who need it. It's going to benefit them greatly. The thing is that there's some better ideas or additional ideas that can be added to this bill. Let me give you my story. When I lived in California, I was getting low-cost internet service from AT&T for $10 a month. When I moved to Las Vegas, I found out that internet option was not available in the area. Now, the question is, why isn't it that Las Vegas have that service? Could we encourage such a move? Another missing element that is not talked about on this bill is unlimited, low-cost, or free data service on their phone. Because as you know, such activities don't have to include in the computer. It can be done going outside. Let's say if they have some errands they do, they want to multitask, they want unlimited data. And it can actually be used as a mobile hotspot in case if they can't get internet or internet connection has been shut off. So with these two considerations in mind, I hope that maybe you can make some revisions to the bill. Thank you so much. I yield my time.
Will the caller with the last 3 digits of 974 please state and spell your name for the record? You may begin.
Thank you, committee members. Randy Brown, Randy Brown, on behalf of AT&T. We'd first like to say we appreciate the bill sponsor's willingness to work with us on this measure. He's been collaborative and willing to consider many viewpoints. As was mentioned by Ms. Terwilliger at the Public Utilities Commission, this bill does provide for oversight, audit, and complaint adjudication by the Public Utilities Commission of Nevada, where none exists today. in essence, creating a disincentive for broadband providers to participate. Broadband is an interstate service that is under the jurisdiction of the Federal Communications Commission rather than individual states. We have spoken with the bill sponsor as well as the director of the Governor's Office of Science, Innovation, and Technology related to the mapping component included in this measure. As was mentioned, the FCC is currently undertaking a comprehensive nationwide mapping effort that will produce accurate and uniform maps depicting broadband coverage at every business and living unit in the country. We appreciate OSIT's recognition that using precious state resources to duplicate FCC efforts is not a good idea. And we appreciate them indicating that they intend to use the FCC maps rather than creating their own. Again, we appreciate the sponsor's willingness to work with us, and thank you for your time today.
Will the next caller with the last three digits of 232 please state and spell your name for the record? You may begin.
Thank you, Chair and members of the committee. For the record, my name is David Dazlich, D-A-Z-L-I-C-H, Director of Government Affairs with the Vegas Chamber. The Vegas Chamber is here today in neutral on AB 388, and we would like to thank the sponsor for the extensive work that he's done with the stakeholders to date and look forward to continuing that work to get the bill exactly correct. As you've already heard from some of the other callers, there are some duplication of efforts and concerns about the amount of money that is already being allocated to these broadband projects. So while we are neutral, we did want to make sure that those concerns are expressed on the record. Thank you for your time, and we look forward to continuing to work with the sponsor.
Will the next caller with the last three digits of 114 please state and spell your name for the record? You may begin.
Greetings, Chair Harris and members of the committee. Amber Stidham, that's S-T-I-D-H-A-M with the Henderson Chamber of Commerce. We are also neutral on this proposal and currently reviewing the amendment. We also appreciate the intent of this bill, although like previous callers, it's our understanding that some of these companies have these programs primarily in place and additionally so with some federal funding. We are also a little bit puzzled, but have some questions on the PUCN's potential involvement and oversight, especially as these businesses are already largely regulated by the federal government. We just wanted to ensure that our comments were also on public record. Thank you so much for your time.
If any other callers would like to provide neutral testimony on AB 388, please press star 9 now to enter the queue. Chair Harris, at this time, no additional callers would like to provide neutral testimony.
Okay, we will go ahead and close out the testimony then, and I'll invite you back, Assemblyman Miller, if you'd like to make any closing comments.
Thank you, Chair. C.H. Miller for the record. I'd just like to acknowledge the mention from the gentleman from AARP of Assemblyman Tyrone Thompson. He first brought legislation that deals with the digital divide back in 2017. It was AB 111. Had his forward-thinking idea at that time passed, we might not have found ourselves in such an issue during this pandemic. More families would have had access to internet as they would have had access through subsidized payments for the services. And to the idea that we're going to have a lot of money coming in from the federal government to support broadband. This is true. But where the federal government is going to end at some point and that $4 billion is going to be expended, we're going to have to continue to invest in our state and our broadband infrastructure to ensure that, again, we are always a totally connected Nevada and no Nevadan is ever left behind due to lack of internet connectivity. So this bill does that. It is a forward-thinking piece of legislation that puts some money in our kitty for the future, or allows us to build and go even beyond whatever the federal government is going to do for us. It allows the community, allows all Nevadans to pitch in at their will, knowing their goodwill donations are going to help other Nevadans have access, so that none of our links are weak, because we are only as strong as our weakest link, right? So I just want to encourage and ask for that support in the form of a yes from the committee, and also remind everyone that the participation from the providers is voluntary, and we worked very closely with PUC to ensure that their jurisdiction was as limited as possible to only focus on the funds that are coming through this program, and to go no further than that. That was something that I cared a lot about making sure that we were able to do, and they were very helpful in working with the language on that. So with all that, I am done. Thank you very much for the time.
Thank you so much, Assemblyman Miller, and I'm more than happy to put my position on the record that broadband is definitely a utility, and I would not be opposed to even trying to get a little bit more regulation in there. So I appreciate this small step forward. Thank you so much. We'll go ahead and close out the hearing on AB 388 and turn it to public comment. BPS, anyone left on the line?
Callers, if you would like to provide public comment, please press star 9 now to enter the queue. Once again, caller with the last 3 digits of 490, please state and spell your name for the record. You may begin.
Cyrus Hojati, Cyrus Hojjaty. Forgive me for bringing this topic again. If I have, we can move on. I think a lot of these issues have to do with the high levels of car dependency and the car culture we have when it comes to insurance, towing, and everything like that. I'd really hope that in the remainder of the session we introduce bills that will deliver alternatives or will change the urban planning system. Urban planning issues is the #1 concern, in my opinion, living in the Las Vegas Valley. We certainly could learn a lot from our old cities, whether it's in Carson City, where you guys are in, or in downtown Las Vegas. There are many issues of why Las Vegas is very car dependent. Believe it or not, Las Vegas is the 5th densest urban area in the country, just behind New York urban area, and more dense than Chicago and Boston. But yet those folks take transit and walk a lot more often than we do. I think that the urban planning problems of Las Vegas can be described as large-scale, single-use zoning filled with maze-like streets, cul-de-sacs, and all these uses feed into these large collector roads, which basically shove and collect a lot of the traffic. This system is heavily unsafe, creates a lot of accidents. It is costly to public and private budgets. Therefore, I think we should institute policies like have been implemented in Minnesota and Oregon that, for an example, would allow more flexible land usage. I certainly think that roundabouts can certainly make a difference as well. We need redistribution of traffic flow. We also have to talk about transit use, depending on what it is. But what we want to preserve is the high rate of single-family homes and free-flowing traffic. More importantly, I believe that this is a very important issue. We can get rid of the codes and regulations that encourage this kind of development. Please, let's have more discussions about this topic. And if we can start addressing this issue, a lot of other problems will be solved. This is disproportionately affecting elderly, young folks, low-income folks, you name it. And I want to just yield my time. Thank you so much.
Chair, at this time, no additional callers would like to make public comment.
All right. Thank you so much. With that, we will be adjourned until Monday, May 10th at 3:30 p.m. See you all then. Oh, for committee members, we will be rescheduling our committee photo. We had several members who were not present, and so we're going to make sure we send that out and get a confirmation back that everyone can make it so that we can get that one under the belt, okay? All right. Have a great day, everybody. With that, we're adjourned.
Bye.